I don't believe we're going to have any guests on the actual virtual option, even though they're more than welcome. Because that's just the LC is me, so that I can screen share. And then we do have quorum because we have 3 out of 5 committee members present. So we are able to call this meeting to order at 1:06 p.m. And is it okay amongst us that we continue to keep recording the meetings?
Absolutely.
All right. Thank you. So as I said, I'm Laura Pangratz, the chairperson. With the rest of my committee, please introduce themselves.
Camilla Rogers, member.
August Lincoln, member.
And then would our, well, we have 2 committee members that are the update on the agenda here, but Keith, Kaiser, and Joe are both excused from today's meeting. Our liaison, would you like to introduce yourself, please?
Steve Jacobs, board liaison.
Thank you. And we do have 1 guest here. Would you like to introduce yourself?
Sure, Bob Hilligus, former board member.
So thank you. Thank you. So this is our agenda. Does anybody have anything to add to the agenda? Is there anything on there that I forgot to add? So hearing nothing to be added or any objections, the agenda is approved. Because we did not have, what is today? Today's July. We did not have quorum at the June meeting. So we're not able to approve the May meetings at the June meeting. So we will do that now. So here are 3, for us. These are the May 9th minutes from our May meeting. Is there any corrections needed? Anybody? Because we've sent this out a couple of times, so, and nobody's had any. So, we get official.
I move that we approve the May minutes.
Second.
Great, thank you. So all in favor, this side of the table, any opposed? Okay. So the minutes from the May 9th meeting have been approved, and I will ask Linda to post them to the website for us. So stick one, pick one and stick one on there for me, please. So I appreciate you being the snack bearer today. I ran out of time. I didn't have time to get them today. So next on agenda. Okay, public comments. So we have a guest here. Would you like to make a comment?
I have some comments to make that I'd like to hold them as long as you suspend Robert's rules during new business.
Okay, all right, we can do that. So just make sure I say it. And then at this time, I will just share my short chairperson's report. So I did attend the in-person, the directors meeting that was held on June 28th. I did email Linda to update the website with our agenda. And then I spoke with Doug Parks about the CO1 request to review. And I also spoke with Elaine Brady about the request to review the revisions for the ARC document. So I still, technically for this round, I only have one more directors meeting to attend or watch, however that may pan out, which is scheduled for July 26th. Okay. Any questions on that? Short and sweet. So Steve, as liaison, I always give you an opportunity to give any updates that you would like to do before we get into the business portion.
Yeah, excuse me, I did send an email to all the committee members about the proposed changes to the ARC guidelines, and I will I apologize because I didn't want anyone to misinterpret. It's my belief that consistent with our governing documents, any review done by this committee of the ARC guidelines is to identify if there are issues that crop up relating to our governing documents themselves. Having said that, what I should have said, and I don't think I did, and for this I apologize. Any member of the committee who has concerns with the proposed ARC guidelines should make a point of sharing those concerns with everyone on the board and even CCing council, as well as the committee, the ARC itself. So that the reason why Elaine had the first reading last month at the last board meeting and specifically said the earliest will come up is in September. In part, there's an election. But that aside, it's also give everybody a chance to review it. And whenever she means everyone, I think she means everyone, because this will impact us all. So I do would definitely suggest, and I apologize for not saying it at the outset, if you have concerns, make sure you send an email to the board, to ARC itself, and if you want to include council. Because I think this is a matter that will get a fair amount of discussion. So,
Yes, I'm sorry, Steve, what version are we in of the ARC guidelines? And where do I find them?
they would be, the suggested changes are somewhat limited. In other words, they've only meant to address certain areas within the
Okay.
broader guidelines. We redid the guidelines probably, I want to say close to a year or so ago. In large part because the legislature changed the
Right.
HOA. You can see the recommended changes. It's in the board packet from the May meeting. It may,
which I did send to everybody. I
Yeah.
pulled out of that PDF. It's dated the June 28th board meeting packet, but I only did pages 32, which started with the charging document, and the 5 bazillion pages. I forget, it goes to like 80 something, in that whole
Okay.
packet. So I pulled that out so that I didn't have to forward the whole thing. So you should have it.
I'm sure I do.
it covers several different sections of the guidelines, and I've already heard from several people who have concerns. So
Mhm.
I suspect this will be a matter of some discussion, and so we should take a few minutes to look it over. Go from there.
I have it pulled up for today, so.
Oh, I'm sorry. The one other thing I would add is
Mhm.
after your emails with Doug about C01, I also spoke to him twice. Once, I can't remember where we were, but also at the last board meeting.
Mhm.
Because I made the point to him that it really did not make sense for us to get a first reading of C01 at the July board meeting because the new board comes in September. He disagreed with me when we had the first discussion. I think, and I'm not putting words in his mouth, but I think he probably does agree. 2 reasons that we can wait on the first reading. One is when he was president of the board, we had an opportunity to vote on a particular resolution. He offered a motion to table, which passed. The justification for doing so was that a new board was coming in, and so they should have the opportunity to review it. And he, sort of agreed that there's not much difference between redoing a first reading because there's a new board or having a motion to table and then coming back to do a first reading. So, and the other thing is my take, and I will be happy to be corrected, but in reviewing his suggested edits, I don't see anything very controversial about it. I don't see anything very controversial about C01 generally. And so for that reason, I think there's no rush to get it done in the July board meeting, we can wait till September, but the committee is free to, let me put this, committee is not bound to vote if you want to at this meeting, and know that it will come back at the September board meeting for the first reading. In other words, you don't have the same problem that the board has this. I don't think it's incumbent upon you to take that into consideration, but whatever the committee decides to do is fine by me. I just wanted to lay that out there.
Thank you very much. So moving to unfinished business status updates. At this point, I will rescind Robert's rules so that for the next two sections, unfinished and new business, we can have a discussion in here. Because our guest is a former committee member and has great insight. But the only thing I have listed for the unfinished business that I put there was that I had been notified right before the July 4th holiday. Took me a minute to realize who was emailing me. Saying that the brick was in and placed. So didn't have, any other opportunity. Thank you so much for going and snapping a picture of it because I didn't make it up there. Let me see if I
It's
can.
right on the outside of the wall. There's some rings, the big plaques are there. It's about the second one in from the wall. That's great.
That's really nice. Thank you for doing
So yeah, so let's see there.
And this little tiny brick is inside. They put in.
Stop sharing. Because it won't let me. Okay, so let me. Trying to make it a little bit bigger here.
I held the camera well and I took it.
Oh, yeah. There it is. Oh, very good.
And let me see if I can.
I was gonna take a toothbrush up and brush it out. For some reason they didn't
There we
clean
go.
it as well as they
All
could.
right, so that is the, it should switch. Just turned it. Maybe it's not moving on this side. Quick enough, but anyway, it does say in memory of James Trummell, Captain USMC Vietnam War. So, so whenever you're up there, feel free to go take a look, yourselves. Thank you again for, snagging that. What I will do moving forward now that we have it placed in a picture, I will coordinate, see if Linda's able to confirm if his wife is still living in the area, because I don't know. I don't,
I meant to, I know, Joe Reynolds and Jim,
mhm.
longtime friends. And meant to ask Joe if he had contact information for Jim's wife.
Because their email that Jim always had
Well,
used had both
well,
their
they-
names on there.
yeah.
So I don't know if she's still using that or not. I mean, I can try.
I will try to get a hold of Joe either by email or phone this
Okay.
weekend.
Okay. And then just let me know because I'd love to be able to get a picture to at least, let them know it's there. So everybody, all of us, participated and to make this come to fruition. So I appreciate that. I'm going to reshare. Oh, there we go. Okay, good. Okay. So now we can move on to so under new business then, we have a couple of topics that we were to talk about. B01 is the book of resolutions. It's ours to review and it was due in April. I think that one is probably still in limbo, but The M08, the association manuals, that was due, for review in February. It did receive a first reading at the May directors meeting, and an update was received in review from legal counsel. And a second reading will most likely happen sooner rather than later. So I'm guessing maybe the July meeting. Is that what you think that one will come before?
Well, I think where we are is, because we didn't have a forum last month,
Right.
the committee has to vote to recommend a version of M08 to the board.
And I don't
With or in lieu of, however you want to phrase it, if you were satisfied with the suggested edits
Mhm.
that council made, then, just, that would be the motion for the committee to approve M08 as received from council with his edits.
I think his edits up on the screen.
Correct.
Okay, that's how, thank you.
Yeah,
That-
most of them, I think, are just,
Yeah.
stylistic. I don't, again, if I look through them last month, I think none of this should be any particular concern. But that's where I can't bring it up for a second reading for committee vote. So that's where we are.
So, to my knowledge, nobody has any objections. Do you have any thoughts on that one?
I read through it and studied it. I agree 100%. There's two periods missing which are typos. For that, it makes perfect sense. I mean, it's one of those issues that had been around almost since I joined the committee, which was 8 years ago. So.
Do either of you have any thoughts on the edits or anything?
I thought it looked like a good revision.
Okay. And I'm pretty sure Keith had responded at some point saying he didn't see anything that he questioned on that one.
And I thought certainly was good enough to put it to bed
Okay.
after 8 years.
So since we do have, we're gonna reinstate Robert's rules for a minute. At this point, since we do have quorum for our committee, do we have a motion to recommend that the M08 with edits approved by legal counsel be forwarded to the directors for a second reading? Is that how you worded, or would you like to break it?
So move that.
Okay.
Second.
We've only got so many of you to take things. Okay, so thank you. So the motion then is to recommend that we have our liaison forward this to the directors for a second reading. All in favor then, please say aye. Aye.
Aye.
Any opposed? Okay. So we can rescind Robert's rules again so that we can have further discussion. So Steve, then, does that satisfy what you need?
Yeah,
To be able to move forward with
Yeah.
that one?
I can get it on the agenda for the.
right. Perfect. All right, so now, the next two things, do you want to look at the C01, which is the committee general policy? I have received a request from Doug Parks to have our committee review his suggested edits to this resolution, which I had sent out prior. He would like to present it for a first reading, ideally at the July director's meeting, with the second reading most likely in September. So let's pull that. So I have it up on the screen. Can go to the first red line that he has under number 4, committee assignments, terms, and miscellaneous procedures. Under B, which is qualifications, it says members shall be eligible to vote and must be the owner of record of Ocean Pines property as defined in section 1.11 of the Ocean Pines Association bylaws. Because that has become a newer thing that is being noted, so then
Well, you
to
might-
keep it up here.
You might remember the trouble that I got into with, Mr. Barr. Steve, do we have any clarification on who is an owner? Because remember, Rick Farr, he's a nice guy,
Right.
was third in succession to the ownership of that home. And he was not an owner in right at the time of that. So what does that mean? Does that mean you can be a trustee and be a successive trustee and you still own the home?
And I'm gonna do this by recollection. My recollection is when we reviewed the bylaws, and I don't think we changed the definition of this section. What we did was indicate in the section dealing with who could run, indicate that a trust or trustee, if named, could be a candidate as long as the trust was not in some sort of corporate
Mhm.
or business function. You know, but if it was a family trust, for lack of a better term,
Mhm.
if you were named as a trustee, you could then be a candidate. I don't think, I could be wrong. I don't think we changed the definitions in section 1.11 or any of the other definitions in that section of the bylaws.
Well, the court, basically all I have been doing is anytime, like we've gotten a new member, I go to the, what is it, the public property search or whatever, and see whose name is on the deed. And it has to be, if it's a husband and wife team, and let's say the wife is the one applying for the committee to be on the committee, the deed has to be in both their names so that she qualifies too, not just,
You're talking about MVAT,
yeah.
Maryland Department of Assessment
Yeah,
and Taxation.
or,
Yeah,
whatever.
that's the
Yeah.
real property record.
Yes, so
Yeah,
that,
okay,
yes.
yeah.
And then, I use that to be able to, on the application form, when I'm recommending or not, but say they're listed as I put in that it was checked and verified that they're an owner, So I think that's become more of a documentation thing now. So,
I understand that part because when I was doing the investigation for who was able to run for the board and had rights and privileges to run for the board or run for any open position in Ocean Pines, that is not, I don't think, Laura, and correct me if I'm wrong, I don't think that's what you just said. I think we need to have a clear definition of who can do these things, because the court has now ruled that anyone who is successive trustee can.
but let's just check, because there may be another update further down that addresses that.
Maybe. I mean, what you're talking about, I remember very well.
Oh, I do too.
And you remember it a lot better than I do.
I got poison
I know,
language. How about you?
You get the death threats. No, but, and there's a big difference between a committee member and a board member too.
Right.
But what happened in this case, I know for a fact, somebody got on the committee the other committee I'm on, that was not a homeowner. He's, his parents or somebody owned the home, but he doesn't own it. So his sense was to make sure it makes it very clear, because he took him off the committee. Now he's eventually going to be on the title, and he come back on the committee as soon as he gets on the title.
Okay, so just section 1.11 of the defines owner of record refers to the individual or individuals listed on the deed recorded in the land records of Worcester County as the owner of property, grantee, parentheses, grantee/party in the second part, within the subdivision to which votes are attributed. If a trust is listed on the deed recorded in the land records of Worcester County as the owner of the property within the subdivision, then the owner of record shall be the trustee or trustees or co-trustees of the trust who is/are listed on the recorded deed of such property. So if you're listed as a trustee,
Right.
you can then, according to this, the change in the resolution, you could then serve on the committee and all that. Having looked at it, it's clear that the definition was changed
It's-
after
Yeah, it
after
sounds
what
like,
happened.
yeah,
That is section 1.11.
Yes,
I am satisfied with
And
that. Okay,
that makes this right then.
I'm guessing that probably what happened was after the committee finished with
Mhm.
all the revisions, we submitted it to the board, council probably changed that because I don't think we did.
I
it.
don't think
I don't remember.
I don't think we did, but that's my recollection.
okay, that's fine. As long as it's there.
All
I
right, so
hate to have
then
anybody else go through that again.
the next,
Can I flag one
Mhm.
maybe technical thing on that sentence, that addition?
Which one is that?
The same one we were talking about.
Okay.
It says members shall be eligible to vote and then the thing references section 1.11. The section 1.12 is what says how you're eligible to vote. So I'm wondering if they should, since they're referencing section 1.11 of the bylaws, I wonder if they should also reference section 1.12
Hold on, I'll
as
go back.
far as eligibility to vote.
Bear with me. Let me get my fat little
And
fingers.
that's basically.
all right,
Yeah,
Tiny desk, tiny laptop. Yeah.
1.12, eligible to vote. Okay, 1.12 says, in its entirety, eligible to vote refers to a member who has paid the annual charges and interest levied under section 5.14A and has not had the right to vote suspended under section 5.13E. You're gonna make me go back to this section.
No,
No.
I was only saying, like, if it's cross-referencing
Should we
1.11, should also cross-reference 1.12.
Just add that
As defined in
in,
section.
1.12.
Yeah.
Just add that. And then
As
you got them
defined.
both covered. if they should.
You just say sections 1.11 and 1.12.
Members shall be eligible to vote, must be the owner of record.
This was never.
Well, I think what you would have to say is leave that as is and just add as defined in section 1.11 of the association bylaws and meets the requirements of section 1.12, because the problem is, well, you could, if you struck owner of record, members shall be eligible to vote
So you could
in
let,
accordance with section 1.11 and section 1.12 of the Ocean Pines Association bylaws.
I don't think you want to, I mean, they added owner of record for a very, it seems important to add, so I worry about.
Mhm.
Okay, so my point is just grammatical, but I don't think you can just add 1.12 after 1.11 because 1.11 talks about the owner of record.
You could add that whole clause. Members shall be eligible to vote as defined in section 1.12 and must be owners of record of property as defined in section 1.11. Or you could just leave it as it is. It's not that big. No one's
Yeah,
gonna
I mean, let's
confused.
be complete. I think you've got a good addition there.
Must be the owner of record of the Ocean Pines properties defined in section 1.11 and eligible to vote pursuant to section 1.12 of the U.S.
That's
Code.
fine, too.
Yeah.
Yeah, that's a good idea.
What was that? Are you getting that wording?
Just-
Once you write it down, then I can, I can, I'll make up an email to send back to Doug saying you did review it and this is our suggestion for that first one.
Because after they changed the bylaws, which I didn't even realize would change, this news never changed. And that's how somebody got on the committee, didn't belong on the
Right.
committee.
Do you think we've satisfied it now?
Huh?
Do you think it's satisfied now that we've got it?
With what? With what he read
Okay,
on the thing.
okay.
It appears that, I don't know how the bylaws got changed without going to vote, but it appears it's correct what's on there.
Well, we voted to approve the bylaws as a block.
Right.
So each individual section was never really reviewed, but when the committee was working on it, I don't think we dealt with that section.
When it went in our
But when it's
committee,
council,
Yeah.
they fixed it because of what you went through.
Yeah.
Yeah, I wrote that.
So then, the next one is the letter D, request for committee membership. The red line says, any member and then meeting the qualification requirements noted in section 4B is encouraged to send a letter or an application requesting membership on a committee. Application forms are available at the Ocean Pines Administration Office, and then the red line there is add and can be downloaded from the OPA website.
Good.
That section there, that's the only red lines there. In letter D. So is there anything, I think that one's fine.
Go.
you,
So. Letter E has been added. And it states that the procedure for committee membership application and appointment is listed in attachment 4, which.
this regular attachment.
And so that's not new though.
So that part's.
It's just it wasn't referenced before.
I think,
Okay.
and then because the other red lines for the next couple ones are just formatting, changing the lettering,
Yeah.
A, C, D, E. So it's F, then G, then H. Number 6 adds the effective date, which could be a 25 now, down to 24. And then the attachments,
I didn't see any. red
the
lines.
first one is the policy. And this is our, the committee report shall be submitted in the format below. This is our annual committee report that we use. It's format.
Let me see that.
Want me to
Go
go
back, just back a little bit. The one thing we kept talking about at this committee way back, and I don't think it ever got in, was when you're doing the annual report, to look at and make sure that your resolutions have been reviewed and are clear.
All right. No, I think
We tried to get that, in,
Well,
and I don't know
I
if that
think
was
that's
made.
in the written portion that I've always added.
Was
Where
that?
we state that we always state that the resolution, resolutions still need to be done or what was done.
But Bob, are you saying for all the committees? And that's what it was?
I think what Bob is saying is
Yeah.
that each individual, not bylaws, but
Each individual.
the aquatics committee has to
should make sure
identify
that
if they are recommending changes to their aquatics committee resolution.
Gotcha, I understand.
Is that right?
Yep, that's
Yeah.
exactly it, because this document keeps getting way behind because committees aren't looking at it. And if in their annual report, they said they're doing it, they're not, then you can go back and ask them why,
Right.
what happened. Because the whole idea of the tracker was for this committee to try to make sure that everything is as current as you can keep it. And they should be reviewed every 2 years, but there's nothing wrong with that as part of your annual report, looking at it and saying, yeah.
You could actually add a sentence after the parenthetical in section 5.
Yeah, I think if you're gonna send it to the board, now is the time to add that to that attachment.
Just add the sentence
Yeah,
after the parenthetical, because it's a recommendation for board action.
yes, the board can turn it down or something to the effect that the committee. We didn't suspend Robert's rules, right?
No,
Robert's rules are still suspended.
yes, correct.
Okay, I gotta be careful.
And we're not voting on
I don't wanna
anything
get
yet.
in trouble.
It's been a busy day. I can very easily forget. All right, so that was attachment 1. Attachment 2 is the charging document that can be used by both either the board themselves, the directors, or an advisory committee. So this is the format that you're supposed to use for that. There are no changes on that. Attachment 3 is the committee meeting minutes format, which I feel like ours are a lot more detailed anyway, but the basic that we, all of us should be following, all committees, is a call to order, who's present, approval of agenda, approval of the minutes from the previous meeting, topics discussed, action items for us, and recommendations for your consideration and adjournment. We go a little bit deeper into ours just because
Yeah.
that's the way I like to do them. But as long as we're hitting all of
That's the
the,
bare minimum.
yes, and right, exactly. And some committees don't even do the bare minimum.
Some committees don't even.
So that one.
Committees. don't
Attachment
even-
4
I'm not getting
is
involved.
uh,
I'm not getting involved.
I know,
the attachment number 4 is for the application for committee membership. And I don't believe there were any red lines on this one that he had. But it's one of the attachments. Oh, and then, because then the next one is if somebody has actually completed a first, a second, and a
Right.
third term. This one is about
Board can-
extending someone an additional year, and how to go about that. And then that's it. There's no more red lines to be dealt with.
Can you go back to the attachment 4, the first page?
The annual report one.
No. Keep going, keep going, keep going.
This one's
Right there,
attachment.
hold on. Oh, no, go back up a little bit.
Keep going up
No,
or down?
I want to read more beyond
The bottom
Roman
of the
2.
form.
Go below Roman 2.
You want to go down to 3?
Yeah, just, hold on.
When I move my cursor here, it takes, if there's a delayed effect on there, so.
And now you can scroll up. Go past C. The other way.
Oh.
No,
Down.
Down.
down. I'm trying to read up.
I'm
Yeah.
directionally challenged, so.
I know, left
Tell me
and
north,
right.
south.
I'm trying to read all of the application. Okay, hold on.
Get all the way through it for you.
Right, an application will be sent to the committee chair for review, right? Here the public committee does not have a chair. Like to coordinate send the application to that person, the application. Okay, keep going down.
Delayed on there, it's not moving on the thing. Yes. All right, didn't move yet, did it?
Not yet. It's thinking about it.
Sometimes what I have to do is just stop sharing for a second. Let it rest for a minute.
Right.
And then
Hung up. Okay, you take all the calories out of it.
Yeah, it's healthy. Made in Berlin.
Okay, now I think you gotta go up,
Back up a little bit.
because I want to read what the committee chair is supposed to do. Keep going.
There you go.
Oh, look, right there. In chair will interview the applicant in conjunction with requirements. Caesar. 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 Oh, bylaws. I should have known that. Yeah.
So my question would be under B, where it says the committee chair will complete the application form with a designation of acceptance or rejection of the application. But then letter I underneath that says regardless of acceptance or rejection, the application is sent to the board liaison for review. Does that mean the board could still approve somebody even if the committee chair doesn't recommend them?
Yeah, because it's the board's decision.
Okay.
I am actually wondering whether or not,
I thought the board
it's up to the
was,
committee, actually.
I thought that the purpose of that was the board is kind of a watchdog of who's getting on and who's not, and keeping keeping it fair and effective are the only things I can think of. But I do think that it does stop with the board, and I think you're right about that, Steve.
Yeah, I mean, there's a provision, one of our resolutions, might be even this one, where members of any committee serve at the pleasure of the board. And in recent years, that's been interpreted quite differently, but, yeah, okay.
That should be. So then the next sections are the board liaison, board of directors, and the administration office sections. You know, once they
Yeah.
get the applications and all of that. Anybody have any questions on that?
Back to my basic question, you want to modify the annual report to include that you have see no changes to the resolution. Because you're gonna send it to the board to make two changes, it's easy to put the third one in. Might
It's in the
help
law.
this committee not having to follow up so much as a reminder for another committee chair.
Yeah, I mean, if it's a recommendation of the committee to put it in that particular attachment, that's what you should do.
I mean, if they don't note it, then it would be, they don't add it as a task that they completed during that 1 year time frame is to review their own resolution. Maybe it wasn't a year that they needed to review it, right?
Question could be, do you see the need for any changes in the resolution? You ask it that way. And there is or there isn't. If there's no need for changes, they can do that every year.
I think my question is, what, if you put something in like that, who then handles that? Oh, yes, we would like to, like that own committee would make their own
Right.
suggestions and everything, but then these reports, they're only shared at the executive council meeting. It doesn't go anywhere else. So other than it does get posted on the website under every committee gets their annual reports posted. But there's no discussion at the executive council level to talk about this kind of
Does
stuff.
the committee have any discussion when they prepare their annual report?
But that's,
There's no input for the committee?
each committee is, to me, I believe each committee operates differently. I mean, we operate.
I know how this committee operated. I know how the committee I'm on now operates, and both are the same. They get involvement from everybody that's there in preparing the annual report to make sure everybody
Right.
agrees with us what they're doing.
Right.
So the simple question would be, you know, has the committee looked at to see if there are any need for changes to the resolution? It doesn't have to be due for review, you just make sure they're satisfied. Maybe it's an extra burden, maybe it's not gonna happen, but if it saved one or two committees having to follow up with the committee to say, well, you know, it's all we're past due, it might solve the problem.
So
Is it a burden?
let me ask a question if I can.
Okay,
Using the tracker. We, every 2 years, chair of the committee sends out a notice to the other committee chairs saying, your resolution's up for review.
Mhm.
Please inform us whether or not you have any changes to recommend. If they say no, we amend the tracker to say they're good for another 2 years.
Right.
If they say yes, it's that committee's responsibility to bring something before the board, correct?
correct,
Yes, and that's in that
okay.
instruction report piece of that is
Okay.
included in that email that I would have
Okay,
sent to
so I guess what I
the
would,
chair.
if you want to include a sentence in the,
Yeah, is
what
it,
did we say, in Roman 5, I think, on that attachment, that says, you know, committee should note any recommended changes for board consideration, or however you want to phrase it. If the committee doesn't do it, we can just update them at the end of that year, whenever their due
And
date
we've
is.
also taken it that if they don't even reply back to my email after X amount of time,
We're
We
gonna
got
get two bites of the apple, right?
and we
right,
reschedule.
then we
Yeah,
mark
that's-
it as reviewed.
But
Okay.
what you're suggesting essentially removes that whole process, because if the committee in its annual report every year was,
Right.
Okay, you're right.
pick strategic planning, if strategic planning every year in response to the change in Roman 5 says committee recommends no changes in their committee resolution, all we have to do on the tracker is update them again for another 2 years. Am I right?
Because it's not their job to come behind them and look at the report and.
Well, they've already said that. We've asked them, are you recommending any changes to your resolution for the board to consider? They say no. They're updated for another 2 years. We don't have to do anything.
Yeah,
Is that what you're saying?
yeah, I think we've
Then
well
we're
enough.
only looking at
If it's working, because we go to them, we say, do you have changes? If they don't get back, we go again, do you have changes? If they don't get back, we just post it for another 2 years, because how important is it? The bigger
Well,
problem,
then would that make all of the due dates and everything for all the C
Yeah.
resolutions the same then? At the end of, reviewed, everybody needs to review it by September 30th when the.
and this committee can't
whatever the-
handle all of them if you did them all in at one time. That's why you got them staggered.
Right, but that's why,
But it's not our responsibility to bring the changes to the board. It's up to these
No, it's
committees.
up to each committee.
Right, so
Okay.
I don't know that,
I withdraw my suggestion.
no, I'm just trying to figure out how it would work.
No, I understand, and to be honest with you, there's about 3 committees, and I'm not gonna name anybody that I can think of that you can never get answers from,
Right,
and the rest of them are good. It's the board that has the bigger problem, because they have more than half the resolution.
oh, yeah.
And those are the ones that we need an active liaison,
Right.
and you've done a good job in getting them to the board.
everybody's been pretty good.
In the past, this committee was like shouting to a vacuum.
No
So,
changes.
No change.
any further discussion on that one?
I don't have a vote. I withdrew my comments.
Okay, so next one up is you want to look at the ARC document. A lot of stuff in that one. Again, it's not gonna come up, the earliest for a second reading, will be September. Because there's no formal like directors meeting in August, and the liaison for that committee will not be at the July directors meeting, which is why she's moving the second reading to the fall.
So this one hasn't had a first reading because it's never been before.
Which one? The C01 that
C01.
we just talked about? Correct. It does not have first reading yet. He wanted Doug wanted our committee to look at it first. And then if we saw anything glaring, then just send it back to him and then, but if none of us see any recommended changes, we can let him know and then he can forward it to the directors for his.
No,
I don't know exactly. I think he's an individual.
he does not, he cannot. Not his responsibility to forward C01 for review by the board. He has no authority to do so.
Because that would have been my only other question
No,
is
well,
what took him to make that.
two things. One is we do have at least one change,
Mhm.
which is the identifying section 1.12 of the bylaws,
Right.
which Augie has authored. The other issue is it would be our responsibility to bring C01 before the board. And as I say, my view, I think Doug is okay with this. You can ask him if you want. But we need to- is that the first reading should be postponed at least until September. Because if we bring it up at the July board meeting, September, we start all over again.
Mhm.
So it does make sense to bring it up to the July board, because we can't get a second reading done before the new board comes in.
Right.
So, based upon that, I think we can bring this back with that one change.
Mhm.
If you want to share it with Doug, go ahead and do it. You know, either before or after our September committee meeting. And then we can bring it up to the board in September. And if he's okay with it, potentially there might be other I'd have to give it to Keith, but there may be other resolutions that we can take up at first reading like we did with the other four and just say, no one raised any objection. There'll be no second reading. The liaison will inform bylaws committee if these have been updated appropriately. So if you want to share it with Doug after Augie has
Just to keep him in the loop too, since
Yeah.
he's the one who brought it to.
but we can get all that settled at the September committee meeting.
Yeah, you got
Okay.
5 or 3 of them that are due in May, so you can bundle them all together for September.
So-
This is your last meeting for September.
Yes.
Right, so I have up on the screen, this was from the June directors meeting. I pulled it out of the packet. This was the whatever you call it, informational, the background. It was presented and submitted by Elaine Grade, who's the liaison to the art committee. So that's what she had included in that. And then this begins the whole section of the actual art document. Okay, so there's a whole mess of red lines in this one. I don't know, because they're saying revision was done in May 22nd of 2025. Now, what I'm not completely,
March.
let me see if I can make that a little bit bigger. What I'm not completely sure, to my understanding, I believe the committee chair is the one who did most of the red line edits. So I do not believe it's gone in front of council yet, legal counsel.
Right.
So if some of the wording isn't particularly clear, I think legal definitely needs to check on that too. That's all under the table of contents there, how they've updated what sections. See if I can get to.
Can I back up just a minute?
Mhm.
What we're seeing now is what has been done or what remains to be done with the art guidelines,
What they would like to do.
what they would like to do.
Correct.
Okay,
That's why I had a first reading.
Everything you read is
Right.
what they would like to change.
okay.
I've really looked at it, went into a lot of detail with it. Were all fuels suspended or not?
Yes, they are still
Okay.
suspended. Yeah.
I just want to be sure.
I appreciate you looking out for me. Yeah. So,
But I looked at a lot of detail on it, I went through it. I would say that as a past committee member, when I looked at it, there are a few exceptions, but other than that, I think the art committee's done an exceptional job in updating the guideline. I have actually three concerns. Okay,
mhm.
these are my concerns. My first concern is, what are these guidelines? Are they an extension of the 34 existing declarations of restrictions? The reference to the art guidelines as listed on page 7, introduction page, paragraph 4, commingles their usage with the established declaration of restrictions. If they are not an extension, what are they? I believe this needs to be reviewed by legal counsel, since any changes or modifications that would affect the declaration of restrictions would require approval by the homeowners. Number 2, my second major concern is the new retroactive requirement to provide a current as-built survey less than 2 years old and performed by a state licensed surveyor. This appears to be costly and retroactive requirement if one wants to sell their home. For the past 57 years, all of the required information and documentation was provided and approved by Ocean Pines before a home could be constructed and verified by Ocean Pines after completion before the occupancy permit was issued. Since OPA has all the documentations on file, why the need for a change that could prove costly and interfere with the sale of an existing home? That's my question on that one. And then finally is the posting of political signs. The state of Maryland, since about 2007, has allowed early elections. In the time period, I think, in that statement that they have under political signs, it should be changed to read 30 days before the early election starts for the primary election, general election, and they're missing the word "or vote on a proposed proposition."
Can I just take this back to my second major concern? What was this recommendation in response to? I mean,
I didn't do anything. These are my questions.
oh, these are your questions.
These are my questions to this committee.
This committee, the art committee is suggesting and wanting to make that a requirement that you have to have a current as-built survey less than 2 years old. So if you just had done 2 years, 2 years ago, but it takes you 3 years to decide you want to do something on your house that needs a permit or whatever, now you got to do it again because they won't accept 3 years later. They're not going to accept that one according to the way it's written, to my understanding, because they want everything plotted out on what's on your piece of property, you know, sheds or whatever that may need to be updated.
All right.
But they're making it, they're stating it has to be by a licensed surveyor, which of course has a much larger expense. One, I believe a gentleman spoke recently at during public comment at a director's meeting that, you know, going through all of that, the expense of that survey was more than what he wanted to do, that needed the permit and everything. And so now he's just not going to do it because, you know, it was going to cost more, double what he was hoping to do.
I can understand this in the era of lead paint poisoning, in the era of substances between walls. And if you're going to gut a wall and it's got some kind of particulate in it that is known to now be a hazard or was a hazard.
I don't think that's under the land surveying, is that?
That isn't what they're asking.
That has,
That's not what they're asking.
Yeah.
Okay.
they're talking about your actual square, you know.
All right.
You have a
You're
square
not
lot,
necessarily this.
what's on
Okay.
Yeah, if you read through it, they're talking to you as survey, it's got a list, all the easements, everything, wetlands, buffer, how many feet, how it's
Yeah.
positioned. And all of that was required when you filed the application with the Architect Review Committee, which was called something else at the time. You know,
Mhm.
I built my house 25 years ago. And I provided every bit of documentation that was required to the county and the Ocean Lines, and they have all that documentation.
But what if you put a shed on your property since that time and it was over in the wetlands? Would that make a difference?
Yeah, it would make a big difference, but
Well, it depends what, if you, if you got, put it this way, if you got a permit from the county and from Ocean Pines to put a shed on the wetlands, in theory, you should have been, you would be grandfathered in from any
Right.
change in the, but I can't believe that either the county or Ocean Pines would grant that approval. Because it's a wetland.
Come and see over in the point where I live, that they granted a permit to build a new house. And
You
it's
got
right, and it's right across the street from George and Teresa's. And the company dug into the wetlands with what I understand, and this may not be completely true, with the combination of the state and those who were giving permits. Then they had to crack up all the concrete, pull everything back out, and they have to start all over again.
Right.
If it had been done right the first time, well, I don't know, maybe I'm.
Oh, is
this
this,
is
is
the
it,
point.
okay. Let me, there's a different, there's two. Well, wetlands are a little bit different than everything else, but as a general rule, you need a county permit and you need an Ocean Pines permit.
Right,
They are not the same.
I know, yeah,
And a lot of contractors file something with the county because they do it as a matter of course,
Mhm.
and they don't bother. That was the concern. For years, I don't think anybody bothered to go see Ocean Pines. That has been taken care of. So in theory, using your example, if you had permits to do precisely what you described, and now you're in violation of the guidelines, in theory, you should be grandfathered in because you have the two permits. Now, I'm not sure what, at that point, let me also add the caveat that if it's all built and done,
Mm-mm.
this is not an ARC matter anymore. This is a CPI matter because it would be a violation. ARC only grants permits and what's the word I'm using? Yeah, even though it's not with our guidelines, you can go ahead and do it. That's ARC's function. CPI is violations.
Right.
Okay.
the one that she's talking about is at the point, it's a house that's sitting in the back and it's been sitting there for 2 years and it's being fought in court because they encroached on the wetland.
Well, it's,
And that one,
No, this one is new construction.
oh, this one is already built and it's been sitting there for 2 years.
Well, right, and I know that one,
Yeah.
but then the party goes on because they came and excavated all the dirt way past the wetlands, poured concrete in the wetlands and past the wetland boundary.
Shame on them.
But-
They just,
But we can't,
that's not what this is about.
And that we can,
All right.
that's an art discussion.
My point is that as a homeowner, and not a member of the committee, I built a house, I complied with every rule that was involved. And now they're telling me when I go to sell it, I gotta hire at my expense some surveyor. He's gotta survey everything, make sure everything is documented. How long is that gonna take and how much is it gonna cost? We don't know
I
yet.
see, okay.
That's
And
at the time of
and I
sale.
can't get a resale certificate from Ocean Pines until I do that. The old resale certificate did not get involved with that and it worked for 47 years. Now they're changing. Why?
Does anybody have any
I'll
other
find it.
questions for, Bob on his questions?
Now Keith has
Because
some
he
too.
did forward, an email to all of us back on July 7th. He said he, reviewed the red line ARC guidelines, discussed, and these are his comments. So on page 10, letter G, second paragraph, the first sentence is clumsy and unclear. He has a suggestion, for page 26, letter G, paragraph 3. It says require screening lattice skirting. I need to read his stuff first before I can switch.
Go back and look at that one.
But as he stated, in that section, there are many types of decorative skirting available today and in use in the pines other than lattice, which is the horizontal skirting boards, are an example. Very popular and look nice. His recommendation is that they remove the word lattice, as that will immediately outlaw many current, new, and recently approved homes. It might be easier to say which types of skirting is not allowed, such as mesh, netting, fabric, etc. Hold on, we'll, page 42. Number 600.4, letter C. This was something discussed to be changed last time, but didn't make it in the red lines. In order to comply with the intent of Maryland HOA law regarding elections, and since Maryland allows early voting, as Bob pointed out, also the 30-day clock should start prior to the commencement of voting for the election. And then his last suggestion was under the same area, page 42, 600.5. His question is why? This whole section is unnecessary. Why can't it just be treated the same as 600.4? It seems to him that this section is just asking for unnecessary trouble and conflicts with membership. Why can't we just use the same rules as section 600.4? All right, so now let me go back so I can see.
For the record, early voting in the state of Maryland started in 2007. That's according to their legal documentation. And it starts actually the Thursday, 2 Thursdays before the general election. And it just varies by county as to the number of times they can vote based on population, the number of times they can hold them. So, I mean,
Can I clarify?
so I feel on Keys, that one is valid.
Mhm.
I've checked with some of the people I know at the state, and they are looking at it to see if it can be changed, because it's a change in law. To change their statement. Because theirs clearly reads, and we interpret it says 30 days before the primary election, general election, or vote on the proposition. That's what it says. Now, before the primary election, so if it's an early election, then it's a primary election, so what difference does it make for a general election? I mean,
Just name.
yeah,
But it's
It's 2
not
weeks.
early elections, early voting.
early voting, yeah, the results are all the same.
Correct.
But so people will have voted almost 2 weeks before they see a sign.
Mhm.
That doesn't make any sense.
Right. Your question?
Let me think about it a little more.
In case, what was the first one he had? That's the one I was concerned with. I thought I missed that. He said, page 10, G, second paragraph, first sentence is clumsy and unclear. And on
It
his,
hasn't moved yet.
lattice work, there is a house built a half a block from where I'm located, a brand new house, and they're using the horizontal lattice work on it. all the way
The
around.
wire, the
Yeah.
hard wire.
Yeah, no wire, metal.
Oh, it's just metal,
Yeah, wood,
wood.
yeah.
I
Or
already know what
plastic.
that looks
It looks like it's, what?
The lattice, what are we
A
talking about?
little diamond pattern needs on the
Diamond.
side.
Where you have
Okay,
like, on my house, my steps at the front door and coming onto my screen porch, the exposed side, because the other side attaches to the house, the exposed side has lattice. So it's, cross,
Yeah.
it's sort of thin.
You got
Now,
a little tiny square.
and the other
so
issue
it's
for me,
decorative, it doesn't have a whole, it doesn't have a purpose.
I think it's, well, in part, yes, you could make the case, well, it keeps some of our critters from getting under your house, whether it
Oh,
does or
okay.
it doesn't.
Critters can get around.
It'd have to be a pretty big critter to not get through those holes, but that aside. the whole back of my house has a screened-in porch. And waist high, from the waist high beam down to the floor, you have to have lattice all the way across.
Okay,
So when I expanded the screened-in porch from just one half of the house to the entire house, I asked the contractor, so why do I have to have this? He says, because you're required to, it's in your guideline. Okay, we'll put it in there. I actually would be perfectly happy to take it down. Because the lattice work is inside the screen.
Mhm.
So the screen covers the exterior.
Yeah.
There's nothing else but the screens, and then I have lattice work on the
Yeah.
bottom. I just soon take the lattice off
Okay.
because half of it's gonna start to fall apart anyway, because it was there when I bought the house 5 years ago.
They used to, all the lattice used to be originally wood.
Yeah.
Now they've gone.
Now you can use
vinyl.
composites. I have a white composite.
It's, I mean, there's a couple things. I mean, Keith is absolutely right on that. What you can use for material should be defined, or what you can't use should be defined.
has the
Right.
state defined that, or?
But like, they'll tell you if you want to put I have gas tanks, if you can see them from the street, you gotta put lattice work around to protect it.
Okay.
Mine are positioned in the house, so you can't see them from the street. You have to walk into my yard. So I don't have to buy, it's never been a problem.
Well, if you don't walk in your yard.
Then it gets into a whole bunch
Yeah,
of,
that's a whole other kettle.
between the homeowners. Like, I can't believe some of the homeowners association that won't be allowed to put a US American flag up. I mean, give me a break on that one. But anyway. So I guess the real question is on Keith's and on these, I think what I'm hearing you say, either as a committee or individually, that they should send an email to the board.
Well,
and
that
the
would,
committee.
that would be what I don't know, and I'd be happy to be corrected, something. The issue of the lattice and with the finishes that are allowed on some of the other exterior pieces and all, I don't see that as a committee function. So, any resident of Ocean Pines should make their views known. I think that's important.
Right.
As to whether it impacts the DRs or impacts the issue of campaign signs, that might be a more colorable, for lack of a better term, claim as to our jurisdiction as the bylaws committee. Any of this, I think, is legitimate to raise individually with the board and council. I wouldn't seek to limit anybody's ability to do that.
Right.
As a committee, you all have to sort of come to grips with, do we have an issue with, but our governing documents cover Maryland statutes, our charter, our DRs, our bylaws, and our resolutions. I don't think I left anything out.
Our guidelines, where are they? I don't know what they are.
Well, yeah,
They aren't
and
in
then,
the resolution, they're
well, you're
not.
amending the guidelines, so.
I was just looking for, and I can't find every document I can find where these fit in, because what they do, if you read the preamble to it, are they're tying them back and forth, compliance with them, both of them, so they're intermixing them, they're one and the same.
But there
I
is,
think it's a modification.
there is a hierarchy of governing documents.
Right.
And the DRs actually take precedence over
Right,
our bylaws and our resolutions. In theory, they would take precedence over the guideline, I think. Because guidelines by definition are just that, guidelines.
but the guidelines say you can't do this unless you do that, that's in the
Unless,
guideline.
well,
That's a
unless you get a
rule.
waiver.
Huh?
You get a waiver.
Yeah. Yeah,
This is,
Well, we had to get one of those.
this
before
would be a topic for a conflict of laws discussion in the law school. That's what
That is our job.
maybe. It's not a federal law, so it's a state law, so we gotta go after
There's
the.
always a conflict of laws in anything. So,
Yeah.
So to get back to what, Steve, and I had said this to Elaine when I asked her if it was okay to share this with our committee, that our role, our job is just to make sure at the committee level that it's not conflicting with anything
Governing
else, whether it's bylaws or the declarations or whatever. That's the only part. If we have questions about, why the need for, survey or lattice or whatever, that kind of stuff, as individuals, we could ask those questions to the committee and to the board for them to look at and
My
have further
question to
discussion.
the bylaws committee is, where is the ARC guidelines? What
They're
are
on the
they?
website.
Because it looks like they're conflicting with the other, in addition to the declaration of restrictions. Unless legal reviews it and said they're absolutely not, and you can make any changes you want. And it becomes a case if somebody wants to take them to court, they take them to court and see what the results are. Ocean Pines,
Don't look at me, I ain't paid.
no, I understand.
No, what?
I think, my real concern is what they're asking for an as-built. Moving forward, I have no problem with it. But when you're making the law or rules that are retroactive to things that have already been approved and documents are provided, that to me is a violation.
Well, okay,
That to you is a violation of what?
the DR.
Of the
Yeah,
DR.
the-
Now, you and I talked about
Yeah,
this.
and
I have a somewhat different take. I don't disagree with what Bob's saying, but to the extent the draft places the burden on the seller prior to putting the house on the lot on the market, to have this as-built survey done. I don't know that the any homeowners association has that authority to do so. I would have assumed, I'll defer to anybody who has a better knowledge of this than I do, but I would have assumed that the cost of an as-built survey, which should be, the committee's stated view is the buyer should be aware of what the property entails when you buy it.
Right.
No argument. I don't have an argument with that. But that should be made available to the buyer when you go to closing. Not at the time where people are thinking about buying a house. And so that would be part of the settlement sheet. It's just like, if you pay all your property taxes for a year and then you sell 9 months in, you should get a 3-month rebate from the buyer. And this is all something that'll get worked out between the buyer and the seller. So it should not be a cost borne by the seller, because if you don't do it and you put the house on the market, you then cannot transfer title free and clear to the buyer.
Right.
And so that's an impingement on your ability to sell your property. I don't know that you can do that.
I don't know that you can do that either.
And there is a resale certificate that exists, and they haven't addressed what changes they're gonna make to this resale certificate. That's what you have to do today to sell a house in Ocean Pines. So now they're changing it and they're going back for things that were already, I would have absolutely no problem with moving forward for properties being built after this date. Those requirements being there if they want to do it. Then people have a choice. Do you want to buy into Ocean Pines or not buy into Ocean Pines?
This is a sticky wicket. It really is.
That's why I'm bringing it up.
Yeah, but you see, but again, I don't, my view would be, I don't know why Park, on behalf of Ocean Pines, is sticking their nose into a transaction between a buyer and a seller. You need a document. And the buyer would get everything. Buyer's supposed to get all of the bylaws and resolutions and ARC guidelines at closing anyway. This would just be another document. That's all it is.
It goes back further than that. I mean, what if the buyer, or what if the builder and the buyer are at odds about what materials were used, et cetera? It becomes incumbent on the buyer to sue the builder for non-compliance with regulations. I don't see where that involves ARC either.
Well, look, except that if you buy a lot that's not been built on, you then have to secure all the appropriate permits. That would be the job, I would think, of the general contractor.
Right.
And that includes both Ocean Pines permits and county permits. And accordance with all state and federal laws as well.
Right.
I mean, okay. But any dispute that occurs pursuant to that contract is between the builder and the contractor. Right. Once you get the appropriate permits. So, yeah, I mean, I think, but my point is a little bit different because I'm talking about where you've already built on the lot and
Right.
you're gonna put your house up for sale.
Mhm.
According to this, you cannot put your house on the market until you get the survey done,
You get a resale.
the as-built survey. And my argument is you get all of this stuff at closing. The buyer is, in theory, is told. I mean, I can't tell you how many people have come to me and said, where do I get my bylaws and resolutions? I said, you got them when you went to close it. No, I didn't. Yeah, you
I
did.
didn't either.
I didn't.
When I bought my house, I got a
There's a lot of
folder
papers in that.
yay big
Yeah.
and about yay thick.
Foreclosures, I don't know. Maybe
I got mine
my
from last
Yeah,
month,
'cause-
because I didn't know what they
I mean,
were.
the time,
I always tell them they're online anyway, but
Yeah.
my point is that all of this stuff should be settled at closing, because frankly, when you go to closing, no buyer is gonna sit there and say, oh, no, I'm not paying this. And the reason why is you got one or maybe two real estate agents who are salivating at their commission.
Yeah.
They will settle this problem at closing where it should be settled. There's no reason for us to get involved in this.
I thank you, Steve. I understand, I'm clear, and I agree.
Yeah,
this
I mean,
is, but this is what they're doing.
So
And
this is
my
something that,
question is, can you do it?
something that should be noted if you disagree with that. As an individual, send
Yes.
it
Mhm.
yeah,
to
and that's right.
the committee
I-
and the board for documentation purposes. For our purposes here, we may not agree with why they even have it in there, but if it doesn't blatant,
Yeah,
unless it's
you're right.
blatantly going against the DRs or something, then
Well,
that's
right.
our suggestion
Yes, you're right.
to them.
Without Bruce looking at it, you don't know whether they're violating the DRs.
And I don't
That calls for a
believe
general.
this version the way Elaine, was communicating, I don't believe legal counsel has looked at this version of the red lines yet. So I think she's waiting to see if she gets input from the community, from, people like our committee or individuals or whoever, and then put it to legal counsel then if our committee then decides to fine tune their red lines, even more so, you know what I mean? I think this is just the first draft and I believe it was done by the
Yes,
committee.
you're right.
And I don't believe legal counsel has looked at it yet. So, and legal counsel, I will say in the past, when we have redline things, they do take a good amount of time and give thoughtful suggestions on how to make sure it's worded correctly. So I do think that should be,
That's my
up
question.
to their liaison, or their committee to request their liaison to submit this and request legal counsel to look at it. If
They
They're gonna
call-
follow the proper
They
line
call
of,
it guidelines, but they're rules and regulations. They aren't guidelines. These are the rules. Either you follow them or get an exception.
I only know what they're called.
I agree. And I think one of the nice things about our community is that we're all very different. All our houses are different and they aren't cookie cutter. And we shouldn't start making things so cookie cutter that you lose the uniqueness of being here.
Number be great.
All right. So I think I can send out another email to all of us so that the two members committee members that aren't here understand. I mean, hopefully they can watch the replay later, but we'll say that if you have any of those questions that don't go with, that don't concern whether it's matching with the DRs or the bylaws, if it's a substance or a topic question, like lattice, whatever, they are more than welcome to individually send their concerns or questions on forward. That makes sense?
Yes.
Do we want to put together substantive comments, or are we waiting for, like, there are some of these are like, I think fall into that bucket, just like, but some of these clearly fall into our committee's bucket. Is this consistent with the restrictions? Is this consistent with HOA law elections?
I would like to try and give us till the September meeting to for us as a committee, if we're gonna put together some stuff, because it's not even gonna, at the earliest, it would be the September directors meeting, but, because we're off for the month of August.
Be careful with the earliest September meeting, because the board could approve it in September. It had its first reading. Second reading is in
Right, but
September.
we,
The ARC
I'm
thing
gonna
is
say-
not the first reading.
Huh? Yeah, it had the first reading.
But
At the June-
our committee meeting comes before the board meeting. I
Right.
sort of like what you're thinking about, Augie. Here's my suggestion would be whoever make a shopping list of those matters that are potentially of concern to the committee, for the committee to review at the September meeting,
okay,
within the what's been submitted for the first reading. Yeah.
Basically.
What Augie said was, where the guidelines will fall, and is it a retroactive? I mean, that's the question. And the general counsel may agree that it's not. That doesn't mean a homeowner can't take them to court and win. The Ocean Pines lost 3 times before, so they don't have a good winning streak.
right?
I think Bruce is a pretty good lawyer, because I used him.
He's making a lot of
when I had a
money.
problem in the marina, but
Say what?
He's making a lot of money, that's for sure.
He still is, by the way.
Huh?
Still making a lot of money.
yeah, he-
As volunteers, we're making a lot too.
So the question is, what can Augie include?
So
when
I
it's
think-
submitted? The chairperson.
Well, if you want to shoot something to Augie,
I've given Augie a
Yeah,
copy
I
of what
mean-
my real concerns are cuts through.
and Keith may have similar issues
Yeah.
that we,
I tried to cover case,
yeah,
and as I said, I've already talked.
but the election signs would be one,
Right.
Well, thank you for everything you've done.
So. So I can send a follow-up, in that follow-up, email to all of us as committee and everything. That. We will go through this and figure out which sections are really our responsibility to look at. And then we can vote and decide at our September meeting, which ideally typically will probably be before the September directors meeting. Unless they change it and meet earlier in the month versus later.
Well, we will, after the election, I'm assuming, there will be some sort of organizational meeting,
Right.
but I don't think it'll be a substantive meeting as,
Right,
our normal monthly.
because that's why I submitted requests for our second Friday of every month through December. I didn't do any 2026 dates yet.
If according to the bylaws, if the committee decided on September to accept it as written, it's over.
If the board,
If the board
Yeah,
decides to
right.
accept Elaine's suggestions as written.
we could,
Can they do that in July?
Huh?
the
No, they're
board,
not presenting it.
assuming,
Assuming.
hold on. Assuming notice is provided in the form of an agenda. Any board meeting after the first reading,
Right.
you could vote on the second reading and approve. You could amend it
Special
and
meeting
still
an hour
approve.
later.
The board would have complete latitude to do whatever it wanted to, assuming notice is given that this matter is going to be on the agenda. Anything, we could take it as written, we could amend it, we could reject it, we could do whatever, the board could do whatever it wanted to.
Right.
Because the first reading has been done, you're now in the second reading. That part is, there's no dispute about that. The likelihood of that occurring, I think, is, on this matter, probably pretty small, but
Yeah.
you're right.
That's the only
But
reason.
Elaine specifically, as the liaison for ARC, said she did not want it coming up for a second reading until September.
Yeah.
Because she is not going to be in attendance at the July directors meeting. So
But the-
if the rest of the board went ahead and voted against her, to go ahead and do a second reading on it, that would, wouldn't she as the liaison put it in for the July meeting?
Well,
Or has it, they don't need her.
I don't,
Because she
I don't, I mean, okay, in theory,
Yes.
if it's on the agenda, it could be called up at any point. Within at the July meeting, if it's on the July agenda, it could come up. But as a practical matter, that's not gonna happen. I mean,
And I don't think she was planning on having it on the July agenda.
well, I mean, I know she said the earliest it would come up for a second reading is the September board meeting. I know she said that. Why, I don't know, but I know she said that. So, I mean, it's not gonna happen. Let's leave it at that.
Okay.
The big thing is, does it violate the bylaws? That's my question.
I mean,
Or the DRs.
Or the
Or
DRs.
any of our.
Mostly the DRs, because the DRs override the bylaws.
State
And
statute.
if you read the preamble to it, it clearly commingles on and on. So I think it's part of the declaration. But they can't change, and of those, how many are? It's about 6 different groups in there. The first group was the original, which was far more restrictive.
Yeah, no, for, I think, less restrictive.
Less restrictive.
Yeah, I think there's, 18 or
No, there was
some number.
27, I counted them, whatever that number is.
And there's, every DR has a separate area.
Right.
And I.
34.
34
There are
DRs.
34 DRs.
So each one would have to be voted on separately in that geographic.
If you open the file and you count the DRs, which is what I
It's
did.
34.
Some of them you have like 17 A, B, and C, and D, and each one is slightly different.
Just as curiosity clarification, because I didn't looked it up myself, but if any one of us in our sections wanted to try, and we're not on this committee or whatever, and get our section, to amend, update whatever the DRs and then vote potentially to approve any recommended changes, can any homeowner in that that particular DR section, who do they come to say, we want to form?
I think there's
you
a,
know,
Beyonce, I think there's a procedure.
Huh?
All I know is that
I
this
have to
came
look
up
it
with the
up.
whole issue of short-term rentals,
Yeah,
okay?
The threshold is pretty high.
And the issue was you can't, the Ocean Pines cannot pass a policy on short-term rentals. They have to do each DR
Right.
separately.
it
And,
requires a supermajority, didn't it? It wasn't just like majority of the.
yeah, but I think part of it too was you could have the election, the vote itself open for months. I mean, and I'm doing, I'm not even sure I was on the board at this time, but I just remember there was a discussion about how do we deal with short-term rentals, and it became so complicated
Yeah,
that they
that
just
is-
said, we're punting on this. We're not gonna get involved. And
So
by
we
the
have
for what
none
it's worth,
right
look
now.
what Ocean City's going through.
Yeah, they
I
are.
mean,
Mhm.
so take what Ocean City's going through and then multiply it by the number of DRs we have.
Florida is so much ahead on that. You look at the homeowners in Florida, and I looked at property down there. You can rent it twice a year. It has to be for
Oh, really?
this period of time, or you can't rent it, period.
Well, each
There are no weekend
HOA,
rentals in a lot of the communities.
each HOA or condo association
Right.
probably is different, but yeah, I mean, they
Florida
have,
law is,
some have restrictions.
in Florida law allows.
Okay.
Anyway, that's not part of the issue today. Today is, what are the guidelines? That's
If you
my
send
question.
out an email getting like ideas, and we had Bob's, I'd be happy to compile it into like one document we can put in September.
Sorry, say that again. My computer was going kerflooey.
Yeah.
You said you're gonna send an email to the community
Right.
and identify issues that may be within the committee's jurisdiction. If you get ideas, people, I could be happy to compile it into one.
Our committee or the our
Our
committee?
committee. One thing we can look at in September, so we have at least
Yes.
something.
We,
In the-
If we
for
need
the
to move
September
it.
meeting, I want something, I think it would benefit all of us as committee members to have something ready to go for the discussion.
I was just volunteering to compile whatever comes in
Right.
into something that could.
Augie's shopping list.
That's good.
Good, thank you.
So I think
Okay. Let me figure out what to do here. Okay, so on the agenda. I think at this point, because we're coming up, we only have 20 minutes left of the meeting. And I would prefer to have the full committee here to finish any of these discussions. That we table the rest, like the B01. And then, for the governance document, the only update that I think I got to put in there was,
Doesn't pull me, you tell me what things.
Yeah.
is, under the committee resolutions, it is C12, the, is it the marine? The marine one was the one that
Sorry.
we had to review, I think. Oh, you know what? I think he did take care of it. Okay.
We're talking about.
But I had
the tractor.
emailed the marine, committee chairperson last time, and they said there was no changes to theirs. I believe that's the one. I'll have to double check that one. So I don't think there was anything else there that we needed to go over right now. Our next meeting is that, well, first, before we get to that, does anybody have anything else that you want to discuss?
Sometimes you send a list of who's, when our committee terms expire. So I
Yes.
feel like some of these are expired. Mine in particular was expired.
Well, get your application.
I was gonna just ignore it and let you stick around as long as you like. No, let me pull that up for you.
Ocean Finance Committee.
Yeah. I believe yours is October. Keith's is September, I believe. I'm on the website, so give me 1 second.
We're getting to the Ocean Finance website.
Yes. Mhm. Okay, so my term does not end till March of 2026, my second one, and after that, I could technically do a third term of 1 year. Augie, yours ends October 15th of 2025. If you wanted to do a second term, that would be 2 years, and we would need to submit it at the September director's meeting to, approve you for term number 2. Keith's final term, because he's on his third term now, ends the end of September, September 28th. I don't believe we can bribe him or convince him to,
I was
unless we
trying to-
could bring in snacks, no.
No, actually, I
For
think
the-
you can.
the extension one
He can be
year.
extended again.
He could.
I'm not
but
sure he
I-
wants to.
I get the feeling that
He's thinking about it, but he's.
Joe's does not, his term does not end till July of 2027. And Camilla, yours, is good until February of 2027. Okay, so, so Keith and Augie, followed by me, are the next ones up. So at this point, unless something drastically changes for me, I'm willing to do a third and final year after that, but,
If you cut
I don't have to deal
another
with that.
committee membership application, bring it with you to the September meeting,
Okay.
she'll sign, I'll sign, we can get it on the
And then
agenda.
you can get, yeah,
Okay.
That won't be an issue.
yeah, because it's a,
If you
it's a
want.
renewal.
Yeah, no, I.
Yeah.
It's not required.
You got a lot of
The alternative is we'll submit one for you.
Oh, yeah, no. And that
We
was
have-
only, the
We
second
have
term
a lot
is
of
only
time
2
with
years.
this.
The third term is a 1 year,
Yeah.
so it goes 3, 2, and 1 is how
Yes.
they do that. So, So, okay, so, let me go back to. So our next, meeting, we do not meet in August because of elections and changing of,
The dark.
the board and everything, yes, so enjoy your month
Can't do
off.
much
You're not
change.
having to worry about anything.
Change.
So our next meeting then would be September 12th. And I did list on the agenda, if you want to go back for your calendars, I have September 12th, October 10th, November 14th, and December 12th for the rest of 2025. I did not submit for the 2026 dates yet. I'll do that in the fall. But they have been all approved by Linda, that this room is available and we can use Teams and all of that stuff. So, okay. Does anybody have any further comments or questions for today's meeting?
I do.
Yes, ma'am.
I kind of feel that in this past year, I've kind of fallen in and out of what I should be doing. And I'd just like to open the door on that and say that for anything, you as the chairman, you, Augie, if there's anything I can do to help you, I don't think I found my niche yet. And I'd like to do that in the coming year, because sometimes I enjoy this committee. I like it a lot, but I have time now to be more involved.
Wonderful. We will
Not
not take
going
you up
anywhere.
on all this, so, you
But we'll
know,
see. Keith does a lot of stuff. And
Yeah.
like if he's
and if he's
cycling
on,
off,
he
Yeah,
will need to transition this document to someone. And that may be something that you could start with. It's not,
well,
it's not incredibly busy stuff.
Take the
You know,
PDFs and
but
convert them back.
Every month he goes and checks it, but, if he is not going to ask for a 1-year extension on his
then
term,
we'll talk.
then he will need somebody
And
to be willing.
I've
to
approached him and he really owns that stuff.
Right.
He really, really, really owns it. He wants to make sure.
Yeah, yeah.
So, and I appreciate that, but
Yeah.
I'm willing to step forward.
Okay.
To do whatever.
Wonderful.
No, he'll have to be eager.
All right, so let me, if there's no, oh, wait, I didn't adjourn tonight.
No.
We have to reinstate Robert's rules real quick. Is there any opposition to adjourning at 2:48 PM? Hearing no objection.